Okay, welcome everyone. I'd like to welcome you to this talk about the realities of reentry for registry-involved persons. I know some of you are from outside of Minnesota. Some of you are from Minnesota. This is an opportunity to get kind of a background of information on what it means to be on the registry in Minnesota, but also primarily what stumbling blocks does that lead to in trying to get on with your life once you end up on the registry. So what I'd like to do here is I'll have the three of us introduce ourselves first. My name is Mark Bliven, and I'm the Director of Risk Assessment Community Notification for the Minnesota Department of Corrections. And what our unit does is deal with all those subject to registration who come to prison and then go back out into the community. That covers more than half of those who are on the registry in Minnesota. Those who are not coming through the Department of Corrections are people who have only had probation cases. But Brad Vandervegt, introduce yourself.
Yeah, hi everybody, and thanks for being here. I'm Brad Vandervegt, and I too am with the Department of Corrections. I serve in Mark's team as the notification coordinator. And so one of my main roles is assisting law enforcement in providing notification to communities on those individuals that are subject to broad public notification, those level 3 designated individuals or those coming out of MSOP following their time there. So yeah, thanks for being here.
And then Tim Dorway.
Good afternoon. Thanks for joining us after your lunch break. And my name is Tim Dorway, and I work professionally at REPOWERED. Some of you may have known us as Tech Dump previously. We recently rebranded, and I am the Work Readiness Program Manager here. And so I run our workforce development program. Privately, I am on the registry. I chose to commit a sexual offense in 2016 and served 40 months in the DOC. This is a very important issue to me, obviously, as a registrant, and feel like I have the capacity and opportunity in my position and with my background to really advocate for change and try and make this system better for all people. So thank you for this opportunity to join today.
Okay, so what we'll do today is I'm going to start out giving a broad view and some of the statistics, some of the information on registry. I'll go through it fairly quickly, but it's important to get a grounding on who we're talking about when we say those on the registry. So I'll share my screen here. Okay, so first thing, here's information for myself and Brad Vandervegt. Tim's will be on a section at the end, his contact information. So first thing important to understand is registration in Minnesota applies to anyone who is convicted, charged, or adjudicated delinquent for specific crimes. So that goes all the way down to age 10. If you are charged with and then convicted of anything arising out of the same set of circumstances, you end up on the registry. So you don't have to be convicted of one of the registration crimes. You just have to be convicted of something arising out of that same set of circumstances, which means if you plead down to a different charge for a different conviction, you still have to register in Minnesota. And that's fairly unique among the states. that charges result in this registration. And something that's kind of surprising to a lot of people is that it doesn't involve only sex offenses. In most states, it also includes the crimes of kidnapping and false imprisonment, which sometimes have a sexual component to them, but not always. We had this question that came up in a state work group on registry, and one of the questions was, well, how many people on the registry do not have a sexual component to their crime? And we were unable to answer that question from the Bureau of Criminal Apprehension because they said they did not have data on that. The Department of Corrections, because we deal with more than 50% of those, we were able to take a look at that information just for those who have gone through the prison system. And we found that about 15% fall into that category. If we look at those on probation, we would expect that that number would be at least 15%, if not a higher number, because of those lower seriousness crimes that don't go to prison. Also, when we do assessments, and we look at those who are level 3s, who are higher risk, level 2s, moderate risk, level 1s who are the lower risk. And what we find is that of those listed as a level 3, only about 2% of those fall under that non-sexual offense crime. So it does apply more commonly to those who are lower risk, which means our level 1s and our non-prison ones, or probation only, which make up at least 70 to 80% of all registrants. So went into effect in 1991. As I mentioned, the Bureau of Criminal Apprehension is in charge of that. And contents of registration: addresses, employment, school, vocational, any vehicles owned or operated. A fairly major distinction with Minnesota, with other states, is that well, we are more inclusive, including charges only. For public dissemination of registry information, it's very limited. It only applies to a very narrow number. So public does not have access to registration information. Now, the public does have access to court records, so they can do a background check on somebody and find out what their conviction history is. But the general public does not generally have access to information about who's on the registry. So as of January 1st, 2022, there were about 18,500 people on the registry in Minnesota. That turns out to be about 1/3 of 1% of all people. One of the big reasons that people don't spend a lot of time being concerned about it, because it doesn't affect a lot of people. But as you'll see as we go through this, it does affect those people who are subject to the registration to a pretty high degree, especially very specified collateral consequences. The legislature did request a work group to review and provide a report to the legislature last year. Actually, it was presented in January of this year. And that is on the public website for the Department of Corrections. We just simply served as the place and organizers of that work group along with the BCA. And that report and those findings are included in that report that went to the legislature. And there were recommendations for review and changes to the registry, but it was a very short time period and not a lot of detail was presented at that time, but it did open the door to further review and study of the registry.
That's the CLE poll for
Yeah,
attendees.
there's a CLE poll, so please fill that out if you're getting credit for this. Okay. So then another part of the registry is community notification, which means that we share information about registrants, but only for those who are getting out of prison. Again, I said it's about 60% of those on the registry have been to prison. So this information is provided, but when we say community notification, we don't mean it goes out to the broad public. It actually just goes out to local law enforcement where the person lives, where the registrant lives. For only a few or a small percentage of those, there is public notification. So when we do that, we make a designation. About 15% end up being designated as level 3s, which mean they're subject to broad public notification. Those are the ones that end up on a website. They're subject to community meetings. Everybody has access to that information about their background. And it's a proactive notification that's being done by local law enforcement about just those designated as level 3s. Currently, there are about 450 of the 18,000 plus who are subject to that level 3 notification in Minnesota. Makes up about 15% of those who get out of prison. 30% are level 2s, which is sort of a moderate level. It's looked upon as more limited notification. And then the great majority, 55%, are level 1s, where there is no public notification, but there is specific notification to household members, to other law enforcement agencies. So, an important thing to know about these registrants, we have 18,000, and a lot of people think of this as, oh, these are the people who are most likely going to commit sex offenses in the community. Well, what we have found is that finding out about those who sexually offend, holding them accountable is the #1 way of reducing recidivism. Those who aren't caught, who aren't reported, aren't known, they're able to reoffend over and over again because they're doing it in sort of secrecy. But those we actually do catch, hold accountable, their recidivism rates are pretty low. For those getting out of prison between 2003 and 2012, we reviewed them for 4 years to see what the conviction rate was on those, and it was only 2.3%, much lower than I think most people think. They think there are high recidivism rates for those who are on the registry. And that is not true. They are very low, and whether that rate is 2.3% or 5% or some other number in that range, it's nowhere near what popular culture sort of thinks of as these registrants will always reoffend. So that's an important thing to keep in mind, is that when they end up on the registry, they've been held accountable, and that has reduced that recidivism rate. Now, I'm going to skip that. And this is about level 2 notification. But another thing that's also important to keep in mind is that people think of the strangers are the ones who are going to be committing offenses. But what we find, and this is not just in Minnesota, but all over the country, this is Bureau of Justice Statistics. These numbers, this report is from 2000, but these statistics don't change. That what we're looking at is that 93% of those who commit sex offenses are committing them against people within their circle, either family members or acquaintances. The very rare stranger type offense that occurs is just that, very rare, but it's the thing that keeps people always concerned. So it's not the person, it's not geographic proximity that's important, but rather what is that social circle proximity. And then age of victims, this is another important statistic to look at, is that age 13 to 17 makes up about 9% of our population, but is about a third of all victims. So that does tell us that teenagers are, that is the most likely time for being offended against. And I think a lot of us understand why that is, that those are those times that teenagers are developing relationships outside the protected family circle. It is definitely one of those times where you want to be more concerned about developing those relationships, because remember, it's in almost all circumstances, it's going to be somebody they know or have developed a relationship with. So what happens when you're on the registry? So in Minnesota, we don't do a lot of public notification, but we have a lot of collateral consequences to being on the registry. And most laws that put in place the idea of collateral sanctions usually look at it and say, well, these folks are all sex offenders, which we know they're not. These are all people who are going to recidivate, so they should be prevented from certain jobs, occupations, even they should not be allowed to live in certain areas because they're uncontrollable and will commit new offenses. None of that is based on reality, but unfortunately, we have quite a list of statutory blocks, occupational statutes, teacher licensing, school board membership. One of the real interesting ones I see is horse racing employment, that you can't have any kind of a job at a horse track or in the horse racing industry. Doesn't matter what that job is. There does not have to be any nexus with your behavior. Simply because you're on the registry keeps you out of that employment. You can't work in food service in the horse racing industry. It's one of the most puzzling exclusions that I think that work group looked at. Another thing is these Commissioner of Health statutes. Failure to inform is deemed endangerment of safety of individual in a healthcare facility, and may deny application to serve as community health worker. Also, under human services, basis for disqualification for position involving direct contact with persons receiving services from DHS license holder. That's a huge swath of people that
Mark,
are excluded.
If you'll let me interrupt here for a second, this
Sure.
is affecting me right now. I have been working for a behavioral health clinic. If you think about chemical dependency treatment, for example, when people are done with their CD treatment, they've been out, they can get peer support type positions. There are courses that they can take to be mentors to other men and women who are in treatment going through the same thing that they have done themselves and are on a track to health. And right now I'm unable to help other people that are, and was told I couldn't report to work any longer because I'm disqualified automatically for any position related to this, even though the area that I am working in is specific to adult male residential people who have committed a sexual offense. So this is just a great example and good timing or bad timing.
Yeah. Emergency removal petition, prima facie case. That's a huge issue when simply the existence of someone on the registry is a prima facie case. And I'll show a little further here. Maltreatment definitions under human services. Registration status falls under the definition of threatened sexual abuse. Even if there's no sexual abuse history or it's not related to the position or what's happening, simply the registration status is defined as sexual abuse. Again, something going to a fairly extreme level statutorily within our laws. So who does commit most sex offenses in Minnesota? This was a report done back in 2004 using information from actually the registry. So this included the entire registry. And of the 585 criminal sexual conduct convictions, only 58 of them involve somebody on the registry. The other 527 involve somebody who wasn't on the registry. So the way I describe it is that if everybody on the registry ended up on the northwest angle, and that's something, an insider geographic thing, but Minnesota has that little piece of the state that's only connected to the rest of the state by water. And so it's kind of an island, although it's connected to Canada. If every registrant was banished to that area, you actually wouldn't reduce recidivism in Minnesota to much of any degree, because again, more than 90% of all offenses are committed by those who are not already on the registry. And it is something that getting that information out to people is that don't limit your awareness of what's going on in your life to those on the registry. It's more likely that those who are going to offend against you, and we see this proof every day, is somebody you know, who often you would never believe would be the person offending against you or those you love or those within your social circle. They can be, again, friends, relatives, professionals who work and live in your social or professional circle. So let me go back. What I'd like to do is hand off to Brad here to talk about some of it, what he runs into as in his work, working with law enforcement agencies, but also his history as an agent.
Thanks, Mark. Yeah, and so to just kind of take the data and really kind of show the next kind of stage, that transition into community. And you heard Mark talk about perception. You heard Mark talk about the sense that probability defies what we know, right? Because something might happen, it's enough or it's sufficient to restrict geographical proximity to places that children may congregate, for example. And we see these rear their head as residency restrictions or ordinances, or healthcare facility notifications on anybody registered. And as our registered population is aging, you know, our first registrants came on in the 90s, and some are still on for various reasons, been extended, and they are going into assisted care living facilities, have never even gone to prison, have never even gotten a risk level, and now they're subject to a healthcare facility notification, and administrators are making difficult decisions as to whether or not to admit them. And just so those unintended consequences. But I want to kind of speak about those community notification meetings and those designated risk level 3. The public perception at any kind of notification meeting is often that it's a place to air a grievance or a place to bring forward a concern. And what we really work diligently to do is to transition that emotion into education. And we use a lot of the information here, but as you might well imagine, it's difficult in a emotionally charged environment such as a notification meeting to really try to bring people into this kind of cognitive frontal, cortex way of thinking about the broader issues that we're describing. And so one of the big things, as you saw from the data that we came away from, is that we saw that community notification does impact recidivism in a positive way. Specifically, one of the key things found is that it inhibits a registrant's ability to create or maintain relationships. Now, it's important to note that in that research, it says all relationships, good and bad, positive and pro-social or otherwise. And this is kind of the crux of some of those issues we see with those unintended consequences, is that now these individuals who we want to ensure are not at least enabled to engage in risky behavior or conduct and formulate those relationships with risky groups like teens, as Mark described. But we also know that we lower that potential risk of recidivism by fostering healthy, supportive relationships. And so what we run into now are barriers where it is extremely difficult for a high risk, high need designee to gain housing, because where there may be housing that's available, there may be a residency restriction that's in place. And you heard Mark say that geographical proximity has zero bearing on risk. Where a registered person sleeps at night is not in any way indicative of where potential risk may exist. We know that folks travel all throughout the state for all manner of reasons, right? So these are some of the barriers to the reentry process. And so one of the unique opportunities going out into communities at times of notification meetings is to really try to transition, like I said, that energy of not in my backyard, not here, anywhere but here, is to really move it to an understanding that by being housed, by being in a situation where they can formulate positive, healthy relationships, we collectively aid in reducing risk. And that benefits us all, because often the sentiment is, well, Brad, what is it to me if this individual who has done harm, that has shocked the conscience, could go on to lead a good life? This is of little to no consequence to me. But we help to really connect that, no, it really is, because an unhoused registrant is a riskier registrant because they have fewer resources, they're destabilized, and we see more issues with compliance on the registry, adherence to treatment protocols or practices, employment, and things like that. And then it goes beyond that. You know, I see, Will, I want to address this. So Will says some people in law enforcement will say off the record that the registry is unfounded mandate that takes up their time dealing with paperwork, and that it does not enhance public safety. Here's the problem, right? Is that we're up against this idea of the registry being something that it is not. It is a policing tool specifically built out of the 90s when Jacob Wetterling had been abducted to aid law enforcement in identifying persons of interest. And that at the time focused on adult males with specific offending conduct against children. And then it grew out of fear, it grew out of anger and malice. And now it is incorporated, as you heard Mark say, everybody from the ages of 10 and even those without actual sex crimes. And so it is these conversations that will hopefully generate enough of the spark of interest and commitment to improving the system, because we're seeing it have a negative effect. And like Mark said, it's a small population, so it is hard to get attention on it, because overall in Minnesota, it's just a difficult mantle to take up. But if we can start the process through networks like the Justice Research Center and so on, we can start to have those conversations about how do we help communities in that kind of NIMBY, not in my backyard mentality, transition into this is better for us all. This helps everybody. And so that's one of my key roles, I think, is to really try to help foster that conversation. Because right now, if I were to go to any community and say, Brad from the Department of Corrections is going to come in and talk to you about the realities of sex offending behavior and conduct and treatment and recidivism, I'd be lucky to get maybe half a room full of people. But if I say Brad's coming to town and he's going to talk to you about a risk level 3 that's now your new neighbor, I get everybody. And so it's a difficult meeting, again, because it's so emotionally charged, it's so based out of fear through misunderstanding and misperception. But if we do it well, and if we work collectively to combine our knowledge and resources, I saw a comment earlier of individuals, Michelle, I think, who was working as a public defender and dealt firsthand with clients dealing with these unintended hurdles and barriers that just made it harder for them to do anything even positive. And so it's just that kind of collaborative outreach. And so I don't want to take too much time. I'm just kind of the middle transition guy. So I want to make sure Tim's got time to speak about his lived experiences and what he's gone through and add some more of that conversation. So Tim, happily throw it over to you.
Well, let me just cover those two questions. Both Michelle and Will, I think it's good to clarify a couple things. And one of those is the issue that I think the work group on registration looked at, is that once on the registry, you're on the registry, and it doesn't matter if you were convicted of that offense or just charged with that offense. Michelle asked about that. Are you treated the same whether you were convicted or not? You are treated the same. There is no distinction at all on the registry. Those 18,000, according to law enforcement, are essentially treated the same. Same registration period, same requirements for verification. And Will brought that up, that there are many in law enforcement that do have those concerns about wasting time on lower needs, lower risk registrants. I will admit that I do see the value of the registry for some, for a limited period, but Minnesota is one of those few places that says, once you're on the registry, it's pretty difficult for you to get off. If you're a lifetime registrant, there is no vehicle to get off the registry. And if you're a 10-year registrant, it is very easy to have that registration period restarted. And I think that kind of responds to Will's comment about the frustration from some in law enforcement that they seem to be wasting their time on some very compliant people that they have to go through. One of the proposals for the registry was to have more flexibility, allow people to get off the registry after a certain amount of time, based on how well they've done in the community. But at this time, Minnesota has absolutely no process for getting off the registry once you get on, other than expiration of the registration if you never do anything wrong.
And I will say too, just really quickly, is that it's an additional burden to law enforcement now with the growing displacement and homelessness within this population of those subject to public notification. They have to check in weekly now with law enforcement, and so it's an additional burden on local policing members to deal with that component of the registration requirement. So it's just we're adding on additional pressures, unfortunately. In that process.
And it is an interesting thing. Michelle also commented about that being on the registry is a roadblock to access for many things, including housing and employment. So the interesting thing is the registry is private information and is not required to be disclosed. But in many situations, employers, housing will put pressure on somebody to disclose their registration status. And if you don't disclose that, you will be denied those services. And if you deny that you're on the registry and it's later found out that you are, that can be a basis for losing employment, losing housing, for not being truthful. So even though the registry is not public, there are plenty of ways to get around that private status on the registry. So I'll pass it on here to Tim.
All right, thank you. As I shared previously, and Mark's in charge of the slide, so I'm gonna have to tell him to bump it up one when it's time. But you know, I was sentenced in July of 2017. Did the majority of my time at Lino Lakes, completed treatment, and have been out since November 19th, which is that tomorrow? No, Saturday. Saturday I will have been out for 2 years. And I just want to take some time to kind of give a realistic picture of what some of these things mean as you're reintegrating on the registry. Registration and reintegration is difficult as it is. It's already hard, and for people that are on the registry and not begging for any sympathy here because, you know, this is a result of my choices. But just the reality and the factual piece is that it's much different and it's more difficult if you are on the registry. I would start by saying more shame. You know, you hear terms thrown around like pedophile, which is used as a blanket term a lot in media outlets. That's not accurate in a lot of cases. You know, I saw I saw a news report a couple weeks ago on a news station I won't name that rhymed with Fox, that was about somebody bringing people across the border illegally, and that he was a convicted sex offender from Minnesota. And obviously, he made choices in his life that had some consequence. But the other part is, my first thought, honestly, was he's probably doing this because he can't find any other work, sadly. And it's one of the few paying jobs that he can get, as bad as that is. More shame. A lot of times with sex offenses, obviously the focus is on your past, and it's not focused on your future or who you are now. And even more so, I would say, in this area. As someone alluded to, more barriers, housing and jobs primarily. You know, in my work here, about 60% of our workforce development program here is registry-involved men and women. And I have a hard time placing them. Even after 18 months in our program of exemplary work, I have a hard time placing them. I had a garbage company call us not too long ago. They wanted to hire our candidates. First thing out of their mouth is, but we won't take any sex offenders. And I just, you know, asked them a little bit, like, what's that based on? You know, are you interested to know some more facts about, you know, like, we run an $8 million a year business with people that are largely on the registry. And they just weren't having any of it. And I dug a little bit deeper, and the reason was because they work in close proximity with other people at that workplace. And I just basically had to say, this is, you know, this conversation is not going to end in a positive way for any of us. So those barriers to housing and jobs are significant, and they are real. People reintegrating on the registry also have more rules. I'll cover some of those here in a little bit. The biggest one is conditional release. For most people who are released from prison, they come out and they have parole time left. So in my case, I was sentenced to 60 months in prison. I served 40. We served 2/3 here in Minnesota. That remaining 20 months is my parole time. That's time that I still owe the state if I were to screw up, and I could be sent back to prison. For people on the registry, they have an additional time of pseudo supervised release / parole. Essentially, it's the exact same thing. The minimum number of years is 5. In my case, I have 5 years total, so I'm almost under 3 left. The majority of people with the sex offense are at 10 years or in some cases, lifetime for people that have gone back. Can you imagine having to live your life perfectly for the rest of your natural life without the fear of being sent back to prison for a mistake? I think that's pretty challenging for anyone. More public scrutiny. We talked about this in another presentation we did. The Nextdoor app is just, you may not have a public notification meeting, but the second someone Googles your name, there's the Nextdoor app, there's third-party apps that just make it real easy. And you can imagine, you know, the conversations that go on them, on Facebook groups, about, you know, the neighbors and all that kind of stuff. And it makes it more difficult. And more misinformation. And what I would say here is what Mark alluded to in this area. Recidivism rates, you know, real recidivism rates don't get passed around on the news. They don't get passed around a lot of times in just casual water cooler conversations, because people are uninformed. And when they're uninformed, they take what they heard last and they pass that on like the phone game. The one thing that's really frustrating to me, and I am level 1, I think my actuarial score was a 0.9%, not even 1% of risk of recidivism when I left prison. When you hear the term with level 3 is the most likely to reoffend, we can get data to say anything that we want. And while technically out of the 3 levels, level 1, level 2, and level 3 persons are the most likely of those 3 categories to reoffend. Most often that percentage rate is less than 10%, if I remember correctly. And I'm sorry, that means you've got a 91% chance of not doing something to hurt someone else by the time you are coming out of prison. So some of the realities, Mark, about registrants on the next slide. First of all, the data does not support the scrutiny. We often talk about incident versus lifestyle. So you got good data so far from Mark and Brad about who is still, who's out, what the recidivism rates are, and those types of things. But one thing that we talk about here is considering when you talk to people about the registry is to think of offense dynamics as lifestyle dynamics or incident dynamics. 40% of the people that are in the Department of Corrections currently, or just under that, have either a criminal sexual conduct charge or a homicide charge. And if you think about those offenses, they tend to be more incident offenses versus lifestyle offenses. Hold on, I'm doing my CLE part here. And so, the recidivism rates are the flip of that. So the ones with the highest percentages incarcerated have the two lowest recidivism rates, homicides and sex offenses. The reality of being on the registration also means, and this is an important talking point for people, is that there are longer sentences. Currently, right now for CSC, the standard kind of sentence, depending on, I would just say in general, most of the people that I was in were sentenced to 12 years, serve 8 in prison. That's a lengthy sentence time. Related to that is when you are in prison for 8 years or for 12 years or for 20 years, you have more of an opportunity for programming, and indeed registrant of program. Most of the people in my program were involved in restorative justice classes. They volunteered in areas inside the prison. They also, took conflict management courses, thinking for change courses, those types of things. And another reality too that I share with people is that treatment completion inside the Department of Corrections takes 15+ months if you are on the if you are taking SOTP, the Sex Offender Treatment Program in the Department of Corrections. If you think about that in relation to chemical dependency treatment programs, most of those run 30 to 60 days. And the Department of Corrections a little bit longer. But you also should note that in the state of Minnesota, according to my therapist, who knows, the average number of times through treatment for a chemical dependency issue in Minnesota is 7. And that is just simply not the case for people that are registry involved and do complete their sex offender treatment programming. All right, Mark, let's talk about the transition back to community. And you can flip through this one very quickly, but Mark says this often and I like it. He says parole and conditional release are the transition, not the punishment. And unfortunately, I think what most people on the registry find is that is not the case, that the conditional release and parole conditions feel like additional punishment and not an opportunity to transition.
And Tim,
yep.
This is a good time to answer the question from
okay.
Kathleen about both why there's longer parole period or supervised release period for those who have committed sex offenses, and is there value in that transition time? First thing, just to clarify, that additional 10 years of or minimum 10 years on supervised release applies to those who are convicted of criminal sexual conduct. It doesn't apply simply because you're on the registry. It's on a subset. So those convicted of criminal sexual conduct, they do get the extra or minimum of 10 years of this transition period in the community. So
thank you.
And then that gives the opportunity, and we always talk about that in the Department of Corrections, is during that 10-year period, we hope that the restrictions are going to decrease all along. As the person does well during that 10-year period, by the end of the 10 years, the registrant should not see any difference between the day before they were on supervision, and the day after it ends. So somebody who is very successful, we hope that those restrictions, those meetings with their agent will be reduced and be unnecessary as long as they're doing well.
Yeah, and I think that's one key thing that Kathleen's question really kind of brings up, is that risk is dynamic. A risk level 3 is not always a risk level 3. With all of the interventions that we apply, there's a very significant decrease in those known predictive risk factors, and the risk assessment tool is redone. And so we work with, as agents, we get, so if Tim was on my caseload, I would sit down with his file, I would look at all the work he's done while in MSOP, SOTP, while he was doing whatever program he was doing in the institution, and would really try to transition a warm handoff onto those conditional release years. Conditional release applies, as you heard Mark say, to those CSC 1 through 5. Yes, I think there was a question of if it is all CSCs. 5th degree, know that it is broken into 2. There's a felony 5th degree and a gross misdemeanor 5th degree. It only applies to the felony 5th degree. And it also applies, interestingly, to felony DWI and murder. So you can kind of see where the state legislature thought about this additional conditional release period being tacked on, and really what it's meant to do. The kind of the foundational thinking behind it is that it's a way to ensure that the individual coming out under these additional years has that time to really work with their agent in that transition, that stepping down process. And that is just so very critical. And then
let's hand it back to Tim.
Yeah, I want to make sure Tim gets his time. Okay, go Tim.
Yeah, so the other thing that I would point out, and I think I stopped in the middle of this thought earlier and switched to something else, is that people that have a sexual offense or are being released on the predatory offender as a registrant do not qualify for minimum level security prison, and they do not qualify for work release in any capacity. So if you have a drug offense and you complete your time, you will, and you do your treatment mandate, you'll likely be eligible for work release, be able to step down that. And then when you are a sex offender or have a homicide, you do not qualify. So I literally went from my cell on November 19th, 2020 to the door without any sort of transition period in there whatsoever. And it was extremely overwhelming. Okay, Mark, we can go to the next slide. And we're down to about 10 minutes, so I'll go quickly through most of these and really only hit a few highlights. So these are barriers to reintegration for most anyone reentering society after a prison term. Housing and employment, we talked about that being much more difficult for people that are registrants. Transportation is just one in general. Fees, there are some unique fees to being on the registry. One is oftentimes treatment. A lot of times the DOC can't get people done with their treatment program before they get out, and so they have to finish their treatment program and then do pretty extensive aftercare, which gets expensive. The other one is the polygraph fees are $350 per test, which is a lot. Legal and family is one that I want to touch on briefly. There is some sort of statutory language. I don't know it well, but I have a lot of friends who do not have family victims whose parental rights are being taken away from them, even against the request of the mother of their children and the children themselves, because the counties are given that power to do that and are spending exorbitant amounts of money trying to retain a relationship with their children legally. And then the registration piece, this is a whole nother conversation one day, but registration causes some barriers, and it really causes barriers to employment if you're required to physically go to the sheriff's department. A frustrating part of that for me is I have been out and being registering for 2 years now. I have not once at law enforcement had one person ask me for identification to show who I actually am. And if that's the case, then we've got all kinds of unique programs in this country, and we should be able to make this work at a kiosk or something like that. Okay, Mark, next slide. And this next slide I usually include when I'm speaking to agents, so you can actually go 2 ahead, Mark. All right, so here are some special conditions that complicate reintegration. First of all, I said the programming as directed by the agent or designee, and that becomes very cost prohibitive. The polygraph, basically anytime my agent asks me to take a polygraph, even though they are not admissible in the court of law in the state of Minnesota, they are used as a tool by the Department of Corrections, and that can lead to a violation if you refuse to take it or are deceptive. Some agents play the game with treatment facilities that if you fail your polygraph, they ask the treatment facility to kick you out of treatment, which then is a violation of your parole. And I know many people that have gone back on that. In my mind, if they're not admissible in a court of law in the state of Minnesota, we should not be using them for this either. Sexually explicit material is an interesting term. I know what that is for me, but there's people all over the state that have different interpretations of what those terms mean. And I recently heard an administrative law judge for the DOC talk about the fact that there's not real clear guidelines about that and that they're trying to develop them. The one on the bottom there is disclosing all internet capable devices. This is a problem, quite honestly, because what isn't internet capable anymore? I had a good friend that just got out of prison and has a flip phone that still has data on it, even though he doesn't want that. Some of us have, not me, but refrigerators with the internet access on the front of them. And so this is getting to be a way for people to get caught up and sent back to prison. Okay, Mark.
I'd just like to say that I've never heard of those cases.
Not the refrigerator. No, I've never heard of the refrigerator, but I have heard of gaming systems and Netflix or smart TVs, definitely. The employment one, I'll touch on a very recent example of somebody, one of our clients here. He was a network engineer before he was arrested, and his expertise is all in computers. And even though the computer that we want him to test is not internet accessible, and he's in the middle of a workroom where everyone walks by his computer screen, his agent refuses to allow him to do that. And he's actually having to move to a different city rather than be around his support network here because of that. Dating sites are a no-no. These are all special conditions on the DOC website that are listed for people with sex offenses. And indirect or direct contact with minors is challenging. People come out of prison scared, and they oftentimes will not put themselves in situations to their own detriment, whether that's applying for a job, being in a public place, going to a workforce center where there are children present, because they just desperately do not want to go back to prison. Last couple of slides here are mostly about the Packingham case versus North Carolina. And what I would say about this is, if you're not familiar with this, this is a problem, I believe, because states are still having old language. Packingham was a gentleman in North Carolina who was a registered sex offender, and in North Carolina it was an additional felony punishable by prison time if you were found to be on a social media site. This went to the United States Supreme Court in June of 2017 was decided. I don't have time to go into it now, but here in Minnesota, I believe our interpretation is causing problems for people, because we still have people getting out of prison that are being told they can't have any access to the internet. And this case was specific to social media and its worth, but if you follow the guidelines that the DOC has right now, you are unable to be on LinkedIn, you're unable to be on Indeed, you are unable to have a profile on WebMD or on Amazon, because people over the age of, or under the age of 18 could also set up profiles on that. Here are some of my arguments against total internet restrictions. There are lots of things to do other than tell people you can't have access to the internet. I mean, think about what we do it for, use it for currently. And so I just want to put a word in there about that. It's an area I think we need to challenge. The biggest issue for me right now, and Mark and Brad are very aware of this, and I really want to say we have a real constitutional precedent that's being set by these city residential restrictions. There are 18,500 registrants in the state of Minnesota, and there are 90 plus communities that restrict people's movement and ability to live there. I live in one of them in my own city. I could be punished up to a misdemeanor for every day that I live there, which technically, although I've been told that wouldn't happen, could send me back to prison. And I think it sets a horrible precedent. It's a scary precedent that we as a government, as a government entity, can restrict people's movement based on what we think they may do. And people's housing is being restricted by this in communities. And it's trying to be challenged in court, but the communities in most often cases will just step back and say, oops. There have been some.
And that's kind of our final word on,
Right.
on collateral consequences, those roadblocks, those things that are standing in our way of successful transition into the community. So thank you all.
Do we have any other questions that we've got a minute for, or are we out of time?
We've got 14 seconds.
All right. My contact information was on these slides. It's available. Please reach out. I'm happy to talk about this, advocate about this. I really don't think I have much to lose anymore. I've already been on the front page of the paper once. Or twice, maybe.
Thank you, everybody. Thank you, Tim. And thank you, Mark, as well. And certainly feel free to reach out to either Mark or myself, as well as Tim, with any questions or follow-up you may have. Have a good rest of your conference.
There might be a few minutes left for questions if anyone has any like burning questions, because after this is like a little 10-minute break. So if anybody wants to stick around and ask them questions, there's a little bit of time.
Yeah, we'll stick around.
I guess I'll just go quickly that
Sure.
When we're pushing for reform of technical violations, and the Minnesota Justice Research Center is going to be spearheading that. And this isn't really a question as much as a comment. You know that the first thing we're going to say is, well, we have to exclude a whole bunch of people, violent offenders, sex offenders. So I want to, and I'm going to work with you three. I don't know how to handle that all the time, because the attack will be immediate and it will be personal, and it will come from people that know better, but are just looking to score political points.
And that's something that's so common, is we're going to exclude from this relief anybody on the registry. What I will tell you, though, is a little bit in contrast with Tim on this, is that there has been great progress in conditions of release and how those are enforced. I think the difference from 20 years ago when I started, even the difference from 10 years ago, that those technical violations are not really leading to returns to prison. Some of them, yes, there are arguments about the value of them, but they are much less restrictive than they were even going back 5 and 10 years ago. So
we're here to support you, though, Will, honestly. And I mean, anything we can do to help just to evolve as you're contemplating how to approach it, we're certainly here as a resource, because it benefits everybody. It genuinely helps everyone be more successful, most certainly.
And none of us are naive to it. Like I totally get that. I get it. There's elected officials involved, and there's money involved, and all that kind of stuff. Thankfully, I don't have to deal with that on a regular basis. I just get to spout off. I do agree with Mark, although I come off as harsh about some of the restrictions that, at least in my experience from the people I know, more people are being shown some grace and an opportunity to try and address the situation and get help. But sadly, as it is with most cases, the application of those policies and laws varies based on where you live. And that's the part I really struggle with.
And there's a lot of old school. Will, you mentioned about law enforcement saying, let's be a little more flexible on the number of people on the registry. Officially, law enforcement always says, we want to keep every tool we have. We don't want to reduce registration because it could possibly, maybe one day, serve a purpose. But you're right. Those who actually have to carry it out, they say, why am I wasting so much time on these low risk and really people who, cooperate very well and probably should be off the registry, but because of our rigid rules on the registry, there's no way for them to get off without the legislature giving some flexibility.
I'm just
And-
seeing
and
Kathleen's comment
It's a
here.
great question. And cognitive behavioral therapy is effective.
Yeah.
And the recidivism rates of people that complete that treatment program changed my life. And it's changed a lot of men's lives.
Yeah.
And it's lengthy, but I would be all for that conversation personally. I have no issue with people getting help. And it's a
Well,
huge accountability part.
And we always need, and we are desperate for non-incarceration interventions. We need community-based intervention programs. As you might well imagine, Kathleen, it's difficult to establish such programs because the minute they go for licensure and say, we're a inpatient intermediary facility that houses men on the registry who are struggling with their conditions of release, instantly the NIMBYs fly. I like to throw that term. It's just not in my backyard. Most people will say, well, yeah, Brad, that seems reasonable. We understand we need some intermediary stuff, but can you build it somewhere else? And that's definitely one of our hurdles. But we appreciate having folks like you contemplating these ideas and really just trying to help us all collectively develop the narrative that's going to hopefully influence and maybe compel some of those more stalwart or rigid thinkers into the next stage of what is hopefully a more comprehensive and thoughtful approach to the whole program of reentry, reintegration, and risk reduction. Definitely.
Yeah, over the last 5 years, we've had a 20% reduction in our prison population, and we are not interested in restoring that 20%. We would like to have more community interventions, which are probably going to be more effective than simply warehousing somebody in prison for a few years and then sending them out into the community again. If we can effectively address the concerns in the community, that's the best place to handle these issues. Thank you, everyone.